Hello, and welcome to Canadian Lawyer TV. With me today, I have Richard Bogoroch, the managing partner of Bogoroch and Associates LLP, and Heidi Brown, a senior partner at the firm. Welcome, Heidi and Richard. First off, Richard, can you tell me a bit about your firm?
Thank you, Tim. That's a very good question. The firm was founded in 1999, and it's grown ever since. We're now 13 lawyers and over 25 support and administrative staff. The firm's goal is to provide access to justice to any individual who suffered as a result of a car accident or as a result of medical or hospital malpractice. Access to justice for us means providing services on a contingency fee basis, that we pay for all of the time disbursements necessary to support the litigation, and we only get paid if we're successful. We also have as our overarching philosophy, provide effective, timely, and compassionate legal representation. What does that mean? We start our lawsuits promptly. We like moving the cases swiftly through the litigation process. Litigation is very time consuming, but by moving cases effectively and promptly, we can achieve settlements for our clients in 2 to 3 years, at least in car accident cases, and longer in medical malpractice litigation. But the goal is simply the same: provide outstanding legal representation, to answer our clients' questions at any time, to use technology effectively to advance our clients' interests, and to provide them with the best possible settlements that we can achieve in the circumstances. We do so by having an effective communication strategy. Clients are provided with copies of all critical documents. They are critical to the litigation, so they make all critical decisions for the case, including when to settle, when not to settle.
Heidi, can you tell me about what your firm's approach is to client communication?
Thanks for that question, Tim. It's a very important question, particularly given that we've been in the midst of a pandemic now for the better part of a year and a half. Client communication has become one of the most important priorities given the difficulties that the pandemic has presented in meeting clients face-to-face. Our firm takes great pride in the way that we keep in contact with our clients. We speak to our clients on a regular basis. We keep them regularly informed and copied on every letter and every report, every important step in the litigation. Our clients are regularly apprised of and kept up to date so that they don't have questions, and it keeps them from being in the dark. In my experience, one of the most difficult aspects of any litigation is trying to navigate through complex legal and medical issues, and the importance that we place on keeping our clients informed cannot be underscored. We want our clients to know the process and feel at ease with the process, and we speak to them, email them, text them, any mode of communication that they feel is the most effective and easiest for them. We try and do our best to accommodate them. And no client should ever have a question and be in the dark about what's going on in their case.
Richard, can you tell me a bit about how mediation is important to resolving disputes?
Thank you, Tim. Mediation is essential to resolving litigation. It's very, very important because it allows parties to settle their cases without going to trial. In Toronto, Ottawa, and Windsor, there is mandatory mediation. What does that mean? It means before a trial date is given by the court, the parties have had to attempt to settle the case through a mediation or alternate dispute resolution process. Mediation is part of the fabric of litigation. It began really about 30 years ago in Ontario, but it wasn't mandatory. It became mandatory at different stages, but now for many years now in Toronto, Ottawa, and Windsor, it is mandatory. Parties need resolution. They need timely resolution. We are a strong and fervent believer in the mediation process. It allows parties to get finality. It allows them of their dispute. It allows them to achieve peace of mind knowing that the litigation is resolved, and allows them to move on with their lives. It's so important. We prepare very extensively for mediation. Heidi and I have mediated thousands of cases over the past. We are, as I said, a very strong supporter. When clients come to us, they have a legal problem. Either they've been injured in a car accident, or they've been victim of medical malpractice, or denied disability benefits. We're here to guide them. It's our honor and privilege to act for them, but we're here to guide them through the litigation process and achieve the best possible result for them. And mediation is an essential tool to achieving result. Litigation, unfortunately, takes time. Because of now the pandemic, the courts have been backlogged, even though they've made valiant efforts to try and deal with the backlog of cases through technology and through Zoom trials. The fact of the matter is cases are taking a long time to reach trial. Mediation is a great way to resolve disputes, and we take it so seriously that as part of mediation, what we do is when you have a Toronto, Ottawa, or Windsor action, they have to be mediated. So what do? We aim for mediation certainly within about 2 to 2.5 years after the incident, so long as we have all the necessary evidence to support our client's case, and we then go to mediation. One thing I should mention is when we go to mediation, we have a meeting with our clients about a week before the mediation to prepare them for the mediation process. We have a letter which goes out to them too. We also have on our website, we have a link where they can see, there's a video explaining mediation, but we prepare them for the mediation process. We discuss our objectives and their objectives and what we hope to accomplish. Now, not every case settles at mediation, but mediation may set the stage for a later settlement. Fact of the matter is that vast majority of car cases, slip and falls, or other personal injury matters resolve in mediation. Not so with medical or hospital malpractice cases, but other types of cases, as I mentioned, car accidents, slip and falls generally will settle at a mediation or certainly at some stage before trial. So mediation is very important for our clients. We take it very seriously. We spend a lot of time on our mediation summaries, which is provided to our clients in advance of the mediation so that they can see what we've prepared on their behalf and to give us input as well. And we, as I said before, take the time to prepare them for the mediation, to give them our objective and what we hope to accomplish, and to explain why their case is worth what we think it's worth, and to give them an analysis of what they should expect at the mediation. So I've gone on a long time, but you can tell that we are very passionate about the mediation process. We believe it's the best way to resolve disputes short of trial. Some cases inevitably have to go to trial when there are really divisions between the parties that cannot be resolved at mediation. But I firmly believe that virtually all disputes can and should be resolved at mediation. Not every one. Some cases have to go to court. There's public policy and other issues as well, but almost every case should be resolved at mediation. Heidi, do you want to add anything?
Our clients are extremely well prepared for mediation, and they have a sense in advance, and this is very important, that our clients are aware in advance of our assessment of the case and the range of settlement that is a reasonable range within which a case should be settled, so that when the mediation takes place, we are not spending a great deal of time trying to manage expectations. It's important that clients understand the assessment, know the strategy, and are full participants in the mediation process. And if the more a client is aware, the more successful, in my view, the result is going to be, because they are a partner in the process. That's really necessary, in my view.
Can you tell me a bit about how the pandemic has affected your practice, and what, if any, of those changes may become permanent?
The pandemic has obviously affected interactions between lawyers and clients and lawyers in the court. Those are the two primary changes that we've seen over the past number of months. So let me first start with interactions with clients. Whereas in the past, pre-pandemic, the norm was having clients in the office and having client meetings in the office. That has completely shifted. And now most of our meetings with our clients are by Zoom or by phone. And in fact, that has proven to be extremely efficient and preferable for the clients, because many of them are traveling from a great distance and they don't want to come all the way from another city to Toronto or to battle the traffic to downtown Toronto. I don't see that changing. The communication is effective electronically, virtually, and that's going to stay. With respect to the court and other important steps in the litigation process, such as discoveries and mediations, those have also transferred from being in person to, by and large, by Zoom. And that too has been a surprising success, certainly for lawyers like us who have cases all around the province, as far north as Thunder Bay or as far east as Ottawa, not having to travel to those cities to conduct a discovery has been a huge time saver, and it's extremely cost effective to handle cases in that fashion. Mediations can also be done that way. Affidavits and documents can be signed virtually. There have been changes in the law as a result of the pandemic where we don't need original signatures for everything, and DocuSign or electronic signatures are sufficing. All of those, which are excellent changes, which are really bringing the practice of law into the 21st century. And I don't see us going backwards from that perspective. The last thing is that we've had trials by Zoom. Richard, in fact, can discuss the trial that he conducted last fall, conducted completely by Zoom with the judge alone. And all of us have been very much surprised by the efficiency of the changes. There's been a new program called Case Lines, where all the lawyers and the judges can have the documents available and ready to access together. And to be able to conduct a trial by Zoom is, again, cost effective, allows doctors who are witnesses, for example, not to have to travel and give up valuable time. So those, in my view, are the positive changes that the pandemic has brought about.
Richard, can you tell me about your firm's philanthropic efforts?
Giving back to the community is very important to us. It's a core value of our firm. We believe that it's a great privilege to be lawyers. We believe that we are given great opportunities to do well, not just to represent our clients, which is our main obligation, to represent them with dignity, compassion, and to ensure that their interests are fully protected. But what's important to us as well is ensuring that lawyers who are in a position to do so make for a better world. And we've done that in several ways. The cost of legal education has increased substantially over the past 10 years. It's very, very expensive to go to law school. We've tried to make it a little bit easier for those who want to go to law school, but who lack the financial means, who simply can't afford it. So we provided entrance scholarships to Osgoode Hall Law School. We provided gifts to McGill Law School. We've also provided funding to Queen's University Law School for their legal aid program. Legal aid is fundamental to our democracy. Unfortunately, given financial cutbacks, legal aid has suffered, and people who rely on legal aid have not necessarily been able to access it. So providing funding to legal aid fits in with our goal of access to justice, but it also fits in with our objective to making things a bit better to the extent that we can. So we're proud of that. And the Queen's University Legal Aid Program is very important. They provide great service to the people in Kingston and surrounding communities. So we wanted to support that. So our philanthropic objectives fit in with our firm's values. And to the extent that we can continue to do so, we want to continue to support legal education, legal aid, and to try and make things better for everyone.
Can you tell me what winning this award means to you?
The award is very important to us, and every day we work very hard to be worthy of it.
Heidi, can you tell me as well what winning this award means to you?
In addition to what Richard said, I think it's important to emphasize that access to justice is something that our firm has taken to heart from day one of the firm's inception. It is incredibly important to us that people get access to justice in a system that has become a legal system that's become increasingly expensive and difficult to access, and particularly in the context of medical malpractice. And we feel honored and grateful to be able to get somebody their day in court that wouldn't otherwise be able to get it. And this award, I think, really makes us feel tremendously grateful to be doing what we do and to be practicing law in the field that we do. And the gratitude is really something I wanted to stress. Thank you.
Thank you, Richard and Heidi, and congratulations again. And thank you for watching Canadian Lawyer TV.